Welcome to the course on medical law. This lecture is about legal responsibility in diagnostics. The concepts covered in this lecture are medical device regulations, classification of medical devices, central and state licensing authority, standardization of diagnostic methods, regulations on prenatal diagnostics. The keywords of this lecture are medical devices, regulatory law, standardization, prenatal diagnostics, licensing authority. The diagnostic laboratories are crucial components of the healthcare system, furnishing vital data to physicians and clinicians to facilitate patient treatment. They have a vital function in the identification and surveillance of illnesses as well as in prevention and management of transmission of infections. So, diagnostic laboratories have an important role in the healthcare system. The adoption of treatment methods and giving of medicines are all based on the reports from the diagnostic laboratories. So, maintaining high quality of standards with regard to diagnostics laboratories is important for ensuring a proper healthcare system. Ensuring the quality of diagnostic laboratories is very important for ensuring the standard of a healthcare system. But maintenance of this quality is not a one-time task, but it should be an ongoing process that demands daily attention and implementation at each stage. This can be guaranteed by following a step-by-step process. First, there should be highly skilled and knowledgeable personnel employed in the diagnostic laboratories. So, there should be rules and regulations which ensure that only highly skilled and competent persons will be employed in diagnostic laboratories. Second, the laboratory should utilize high quality equipment that is meticulously maintained. This means that there should be regulations which ensure that only high quality equipments which follow the prescribed standards will be used in the laboratories. Third is appropriate preservation of specimen. This means that there should be some regulations which provide the standard that has to be followed for preservation of specimens. Appropriate manipulation of specimen by laboratory personnel and others. This means that the personnels who are employed in the laboratory should be competent enough to manage the specimen and do the analysis. Now, let us see the existing legal framework applicable for diagnostic laboratories. The Medical Device Rules 2017 issued under the Drugs and Cosmetics Act is a significant legislation which is applicable to medical devices. As part of the diagnostics regulation framework, the Medical Device Rules of 2017 govern the medical device manufacturing, import, sale, distribution and quality and safety supervision. It categorizes risks, sets product standards and set license dates. The Medical Device Rules 2017 comprehensively covers various aspects with regard to the standard of medical device, including its manufacturing, import, sale, distribution, quality and safety, etc. The Medical Device Rules is issued under the Drugs and Cosmetics Act. It was issued in 2017 and subsequently it has undergone several amendments. The Medical Device Rules provide for classification of medical devices into 4 different categories. The categorization is determined by intended application and the corresponding hazards, and it is in accordance with the criteria established by the Global Harmonization Task Force. Now, let us see what are the 4 distinct classes. Class A deals with low risk devices. These are subject to relatively simple regulatory requirements. The Loris devices includes devices like thermometers and blood pressure monitors, which are external to the human body. So, their use may not have direct effect on the human body. So, they will fall into class A, which is having relatively simple regulatory requirements. Class B covers devices which fall into low to moderate risk category. This requires compliance with more regulatory control compared to class A. Examples include hypodermic needles, suction equipment, bone fixation plates, etc. Class C deal with moderate to high risk category. Devices like cardiac stents, orthopedic implants, etc. fall into this category. Class C is subject to more rigorous regulatory scrutiny and may require clinical data also. Class D deals with high risk devices. Implantable devices such as implantable defibrillators and drug eluting stents are falling into class D. They require highest level of regulatory control, including comprehensive data on safety and efficacy. It is expected that all medical equipment would adhere to the standards which are outlined in the Medical Device Rules 2017. The central government has established a standard for medical devices which are specifically outlined by the Bureau of Indian Standards. So, if BIS standards is available for a particular category of medical device, then all the manufacturers will have to follow the BIS standards. But there will be cases in which the BIS prescribed standards may not be available for a particular medical device. In such cases where there is an absence of BIS standards, they have to follow the standards established by International Organization for Standardization, that is the ISO, or the International Electrotechnical Commission IEC, or any other relevant pharmacopoeial standards. In cases where both A and B are not present, adherence to manufacturers' verified requirements is required. This is provided in Medical Device Rules of 2017. The Medical Device Rules 2017 provides for constituting of licensing authorities at the central level and also at the state level. The central licensing authority shall be the competent authority for enforcement of the medical device rules in relation to import of all classes of medical devices, manufacture of class C and class D of the medical device, clinical investigation and approval of investigational medical devices, clinical performance evaluation and approval of new in vitro diagnostic medical device, and coordination with state licensing authorities. So, devices or activities which require stringent control are coming under the regulatory purview of the central licensing authority. The state licensing authority shall be the competent authority for the enforcement of the medical device rules in relation to manufacture for sale and or distribution of the class A or class B medical device which require less stringent control. They are also responsible for the sale, stock, exhibit or offer for sale or distribution of medical device of all classes. Registration of laboratory. Before the approval, the medical device has to be tested in a recognized laboratory. To request registration of a medical device testing laboratory for the purpose of testing or evaluating medical device on behalf of a manufacturer, an application shall be submitted to the central licensing authority via the online portal. The registration has been granted once will be valid indefinitely unless it is suspended or terminated. However, the registrant must pay a registration retention fee in order to maintain the validity of the registration. Conditions for registration of medical device testing laboratory is also provided in the 2017 rules. The location where the test of or the evaluation will take place must have adequate lighting, ventilation and space. Prior to the granting of the registration to any laboratory, the premises must undergo an inspection by medical device officer. If the purpose is to conduct experiments that involve utilization of animals, the applicant must establish an animal facility and adhere to the supplementary criteria. Apart from the medical device rules of 2017, another significant legislation which is applicable for clinical laboratories is the Clinical Establishment Act of 2010. The Clinical Establishment Act aimed to register and regulate clinical establishments in the country. Its purpose is to define and enforce minimum standard for the facilities and services offered by these establishments. The objective of the Clinical Establishment Act is to provide access to a comprehensive database of authorized clinical establishments. The definition of clinical establishment is given in section 2C. It covers any clinic which is providing diagnostic services to a patient. It can be controlled or managed either by the government or by private entities. So, irrespective of whether it is managed by government or a private entity, they have to be registered under the Clinical Establishments Act. But if it is an establishment owned, controlled or managed by the armed forces, then registration under the 2010 statute is not required. The conditions for registration can be seen here. The clinical establishments must meet the required minimum criteria of facilities and services for registration and renewal. The personnels who are employed in the clinic must meet the stipulated minimum standards. The requirements for upkeep of records and submission of reports are also specified in the Clinical Establishment Regulation and Registration Act of 2010. The clinical establishment is obligated to offer medical examination and treatment utilizing the existing staff and facilities to stabilize the emergency medical condition of any individual who arrives or is transported to the establishment. The other conditions are they have to exhibit the registration certificate in a conspicuous manner. They have to exhibit the fees levied for each category of service rendered and the amenities offered prominently in a local language and in English for the convenience of the patients. They have to apply the rates for each category of procedures and services within the range established and released by the central government. The purpose of this legislation is to ensure adherence to the standard treatment guidelines established and released by the central government. The clinics have to preserve and furnish electronic medical health record of each patient as prescribed and issued by the central government. They have to also ensure the proper upkeep and dissemination of information and statistics in compliance with other relevant and currently enforced laws and regulations. The Government of India has introduced the minimum standards for medical diagnostic laboratories as a schedule in the Clinical Establishment Central Government Rules of 2012. So, under the Clinical Establishment Regulation and Registration Act, there are several rules issued by the central government. In the rules, there is a schedule which deals with the minimum standards for the medical diagnostic laboratories. The clinical establishments typically utilize laboratory or other medical equipment to conduct various diagnostic or investigative services, including but not limited to pathological, bacteriological, genetic, radiological, chemical and biological investigations. The aforementioned institutions are required to adhere to the prescribed minimum requirements for facilities and services outlined in the schedule. The notification has characterized these establishments into three different categories: basic composite, medium and advanced. The requirement for each category of establishment has been further divided into desirable and essential. Please refer to the schedule of the rules for further information. The standards which are prescribed in the rules cover the following areas: infrastructure, human resources, medical instruments and testing tools, procedures and rules, legal and government rules, and the upkeep of records. The drawbacks of this legislation are: this legislation presents the following drawbacks that have resulted in a disparity between desired goals and the actual results. According to the statutory framework, Clinical Establishment Act is exclusively applicable to states that have voluntarily decided to implement it. Even though it is a central legislation, it is not equally applicable to all the states. Some states have chosen to develop their own state legislations. So, in such cases, the Clinical Establishment Regulation and Registration Act of 2010 will not be applicable to that state. In the states where the Act is currently in effect and operational, the regulatory role is restricted to the issuance of laboratory registrations and the maintenance of a registry of clinical institutions. The laboratories engage with the regulatory authorities just during the registration process, whereupon they provide documentation demonstrating their adherence to the specified standards of registration. Once a permanent registration is obtained, there exists no system for evaluating the operating efficacy of laboratories or addressing the grievances from the patients. This is a major drawback of the regulation. Apart from the Clinical Establishment Regulation and Registration Act, another legislation which is applicable for diagnostic laboratories is the Shop and Establishment Law. Private laboratories are subject to regulations in accordance with the provisions outlined in the Shop and Establishment Law of each state. This law governs the matters such as holidays, cleanliness standards, and working hours. It is obligatory for such entities falling under the purview of the Act to seek registration under the corresponding state legislation. It is not necessary for the central and state government entities to acquire registration under the Shop and Establishment Act, but private clinics will have to register themselves under the Shop and Establishment Act before they start operation. The certificate or licensing services are a fundamental requirement for starting of the business. The certificate issued for the purpose of acquiring various other licenses or registrations related to business operations. So, once the certificate of registration under the Shop and Establishment Act is received, it can be used for acquiring other licenses and registrations. It functions as an evidence of the existence of the business establishment. Apart from the different legislations that we discussed till now, the Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Selection Act of 1994 is also applicable for diagnostic laboratories. The Preconception and Prenatal Diagnostic Techniques Act of 1994 prohibits the practice of prenatal sex determination. The regulatory framework was further widened after the 2003 amendment. The legislation was initially introduced in 1994, which was significantly amended in 2003, which also led to a change in the nomenclature of the legislation. Any genetic counseling center, genetic laboratory, or genetic clinic that provides counseling or performs prenatal diagnostic technique such as in vitro fertilization with the capability of sex selection are subject to the regulation under this Act. Okay. So, now next is conclusion. So, I am going to conclude. To conclude, the diagnostic laboratories sector in India is anticipated to have substantial expansion due to the increasing healthcare demand. It is important to acknowledge that the lack of regulation within the industry remains as a significant issue and it offers risks to patients. There exists a lack of awareness among the individuals regarding the distinction between an accredited laboratory and a non-accredited laboratory. The absence of the legislation is a primary reason for this situation. The references of this lecture can be seen here. Thank you very much for listening to the lecture. I hope you are enjoying the course.